Hello, and welcome to Crime in Court. My name is Heather, and this is another Delphi update. So earlier this week, we read through the defendant's motion to compel discovery and for sanctions on prosecutor Nicholas McLeland. So now we have Nick's response, which is what we're going to read today. All right, so let's just get started. Please give this video a like, subscribe if you're not already, and thank you so much for being here. All right, let's begin. So the state's response to defendant's motion to compel and request for sanctions filed April 23rd, 2024. So comes now the state of Indiana by prosecuting attorney Nicholas C. McLeland and respectfully files its response to the defendant's motion to compel and request for sanctions filed April 23rd, 2024. The state would ask the court to consider the following. Number one, the discovery in evidence is that discovery is evidence in a case that the state intends to use at trial or evidence that tends to exonerate the defendant, referred to as exculpatory evidence. Not all information gathered in an investigation is discovery. I see where he's going here. Number two, the investigation into the unalivings of Abigail Williams and Liberty German spanned over 6 years with thousands of tips and hundreds of investigated leads. Number three, that the state made the decision to hand everything over to the defense attorneys and not make a determination of what was discovery and what was not. That amounted to over 26 terabytes of information. Hold on, that dog is trying to... She always has to ruin the stream as soon as I start. Really? As soon as I start. Sorry, guys. All right. I think she's comfy now. All right, so that amounted to over 26 terabytes of information. Number four, the exchange of information began in 2024 to the current defense team. Upon their removal for violation of the court's order... That's why they were removed. We were never told why they were removed. We just were told that they were no longer in the case, and then we found out that they were told to basically let her tarnish their names publicly or recuse themselves from the case, which is what she did. Once it was returned, so they're talking about what? The exchange of information, the data, so the discovery. The exchange of information began in 2022 to the current defense team upon their removal for violation of the court order. I have problems with that wording. The discovery was returned to the state and then forwarded on to new counsel. So we had Scremin and Libredo on for a temporary basis, a few months, while everything got hashed out with the Supreme Court, and they reinstated Richard Allen's attorneys, Baldwin and Rosie. All right, so once it was returned, the state had to sort through it and make sure everything was accounted for before it could be forwarded on to new counsel. Once original counsel was put back on the case, so after they were reinstated, the discovery had to be collected from new counsel, sorted through to assure it was all there, and then forwarded again to original counsel. This was a huge endeavor by the state that consumed hundreds of hours of work. Well, that ain't our fault. I keep saying... I'm all stuck on the Commonwealth because I'm in Massachusetts right now with Karen Reid. I'm not literally. My mind is there. So, yeah. It's not the defense counsel's problem that you guys took him off the case with no warning or no reason, and then put on new attorneys and then took them away. Well... it's also not the defense's fault that they got reinstated and now they have to go through everything again. But yeah, so I don't know what his point is. Life is hard. Everyone's got issues. Everyone has to deal with problems. So get over it, Nick. All right, number 5. Throughout this process, the defense has inundated the state with inquiries on where to find certain documents. Well, maybe they wouldn't if they knew where everything was. And if you guys didn't try to hide everything in like some kind of hidden they hide the names of things. They misname things, misidentify files on purpose, I believe. So the state has endeavored to assist the defense in finding documents that they are looking for in the information provided to them. Oftentimes, in this endeavor, the state finds that the defense had the documents all along, but that they could not locate them. Well, maybe you shouldn't try to hide them from the defense team. The state has no idea why the defense cannot locate the documents, because of reasons I just said. The information is organized for the state in the same fashion as it was provided to the defense. In order to find documents, the state has to dive into the 26 terabytes of information, often searching several files before documents can be found. The defense seem to want to circumvent that procedure and just request that the state find the documents for them. The state has done its best to appease the defense. Are you freaking kidding me? They can't find these documents. I don't know why. They're so dumb and they can't understand the simple organization that we used of this 26 terabytes of information. I don't know why they can't find it, Judge. And frankly, we're sick and tired of helping them look for it. Wow. 6. That on April 16th, 2024, the defense sent an email asking the state to turn over certain documents. The defense then sent another email on October 23rd, 2024, asking the state to turn over additional documents. Well, that's because you weren't turning the documents over. So, yes, they kept requesting more information from you. The defense then followed up with their motion to compel and for sanctions. Number 7, Trial Rule 26 states that before any party files any motion or request to compel discovery pursuant to Rule 37 or any motion for protection from discovery pursuant to Rule 26C or any other discovery motion which seeks to enforce, modify, or limit discovery, that party shall 1. Make a reasonable effort to reach agreement with the opposing party concerning the matter which is the subject of the motion or request, and 2. Include in the motion or request a statement showing that the attorney making the motion or request has made a reasonable effort to reach agreement with the opposing attorneys. So you just want the attorney to write a letter saying, we've had a lot of difficulty getting this information. I mean, what's the difference if written or on the record, whatever, concerning the matters set forth in the motion or request. This statement shall recite in addition the date, time, and place of this effort to reach agreement, whether in person or by phone, and the names of all parties and attorneys participating therein. If an attorney for any party advises the court in writing that an opposing attorney has refused or delayed meeting and discussing the issues covered in the subsection F, the court may take such action as is appropriate. Number 8. The court may deny a discovery motion filed by a party who has failed to comply with the requirements of this subsection. But if you didn't fail with your compliance issues in the first place, then they wouldn't have to be doing this, Nick. Well, the real problem is you, Nick. If you can't see that, but obviously not. Number 9, that upon receipt of the email from the defense on April 16th, 2024, the state began looking for the documents that the defense was requesting. Not only did the state confirm that they had already received much of the information that they were requesting, but also the state began to pull the information out of the 26 terabytes and separate it into individual folders for easy access for the defense. So what? I don't know. I don't know what. Okay. Number 10. That much of the information that the defense requested is not even discovery in this case. meaning that the evidence is not going to be used by the state at trial, nor is it exculpatory to Richard Allen. Number 11, that on April 26, 2024, the state of Indiana provided a response to the defense emails that included a letter explaining what was handed over, as well as a zip drive and hard drive that organized the information they requested into easy access folders. I have a feeling, though, it's a little more complicated than that. I think the state deliberately, purposefully, and it's pretty, well, I don't know if it's been corroborated by others, but it almost seems like the defense is just hiding things, naming things the wrong thing, and purposely handing over extra information. This is actually, if you look in the description below, there's links to other Delphi videos that I've done, and we went through the motions for contempt hearing where Nick McLeland, or they brought up the fact that Nick McLeland, would be inundating them with all this information, all this, videos and audio and files of cases that might not even have anything to do with this case. So it's almost like they're trying to purposely drown them in discovery so that, and the whole taking them off the case delayed them going to trial. So I think it's all delay tactics by the state. And Judge Gull somehow in on it. I mean, they all are. All right, so number 12, that the state's response was delayed because the state searched through all the information involved in this investigation, pulled the files from the information, and put that information all in one convenient place so that the defense did not have to search for it. Basically, the state took hours of its week to do the defense's work for them so that it was all convenient as possible for them to access the information they requested. Who do you think the judge is going to believe versus this version or the defense's version? Because as we've seen, she very, very seldom rules in favor of a motion or an objection that is brought forth by the defense. You can tell, like, her disdain for the defense comes off in the transcript. And it's just a transcript. It's no audio. Like, you can just tell that she does not like the defense. All right. So all while attending several depositions set by the defense of various witnesses that the defense planned to call that spanned over several hours, occurring in different parts of the state. So he was attending all these different depositions while he was doing the defense's work by organizing the files in some manner. I don't know. All the information requested by the defense, minus the SOPs and the chain of custody documents, was already in the possession of the defense. 13. That the state believes it has compiled with the request from the defense in a timely manner given the circumstances, and that sanctions that the defense are requesting are not only unnecessary but wholly unreasonable. I don't think they're wholly unreasonable. You've asked for them to go to a contempt hearing. So how can they not ask for sanctions on your misconduct, which has been proven in the court filings, the court documents, the transcripts? It's there that Nick has been doing his own kind of contemptuous conduct. All right, so 14, that the state has also turned over all known Brady material to the defense in its letter dated April 26, 2024, which consists of no Brady violation information. So they're saying there's no Brady. All right, 15, that the state did not delay turning over evidence from Todd Click. The state turned over a report from Todd Click to the defense that was not discovery but was information gathered in the 6-year investigation. Further, much of the information in the Todd Click report was duplicative of the information in the Indiana State Police report turned over to the defense months prior, plainly, the defense had the information in the Todd Click report all along because it was duplicative of what was in the Indiana State Police reports. The Indiana State Police had documented the same information that Todd Click documented, all of which is irrelevant because the information was received in both forms of the defense, or by the defense, well before any trial date. 16, that the state did not mislead or lie to the defense in an email. That the state turned over, the judge has to decide that. But I think she'll side with the state because that just seems to be her thing. Number 17, that the state turned over information between September 8th, 2023 and October 6th, 2023. The information was turned over days before defense counsel withdrew from the case. You mean were forced to withdraw from the case. But within the discovery time limit set by the court. So he turned it over within the time limit discovery. And again, all of this is irrelevant because the information was received well before any trial date. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClelland, and files their response and would ask the court to dismiss defendant's motion to compel and request for sanctions without a hearing. And again, because that's Judge Gull's thing, she likes to press that denied without a hearing button real often in this case. And I believe that's what she's going to do. What do you guys think? Let me know in the comments below. I would love to hear your thoughts. And don't forget to hit the like button on your way out and share this video with anyone who you think might find it interesting. I am out of here. Thanks so much. Have a good one. Bye, guys. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.